Welcome to class number 8. This is also going to be a very long class and probably one that interests you. It certainly interests me, which is American criminal procedure. This is something that has been very influential in our country recently. I think, if you look at the legislative reforms being done in the past 10 years, a lot of it has been inspired by American criminal procedure. And like I said, usually procedure tends to be more important in a common law system than the actual law itself, especially in criminal matters, because like I said, all criminal matters really have to be decided by a jury unless there's a plea deal, so the procedure becomes extremely important. So just some basic terms here. The investigation conducted by law enforcement authorities. There's a multitude of law enforcement agencies in the United States. You have your local police departments, so all of them do conduct investigations. Usually you have your detectives, you're conducting the investigation. The arrest itself, with probable cause, you can go and arrest a suspect. Usually when you do, the arresting officer will read the suspect their Miranda rights so that they can use anything that the suspect says in the prosecution's favor, right? So against the defendant. But it's not a requirement. So if the arresting officer doesn't read the defendant their Miranda rights right away, that doesn't invalidate the arrest. So this is sort of a popular culture thing that you see in some movies. Usually the Miranda rights are most usually read before the interrogation, which happens at the police station, because then it becomes essential, because without the Miranda warnings, the interrogation cannot be used in court. So charging, basically after the police has conducted an investigation, the prosecutor, so it's going to be usually the district attorney. In some jurisdictions there might be a different name, but it's the district attorney being the chief prosecution officer. It's usually an elected position. He will decide whether or not to charge the suspect with the crime. The arraignment would be when the suspect is brought before the judge, and at that point they enter a plea. So in the common law systems, it's very common for the defendants to have to enter a plea. They have to say, I plead guilty and I plead not guilty. And this is interesting because this is very different from confessing in our country. When you confess in our country, that's a form of evidence which needs to be analyzed by a judge. But when you plead guilty, even if you don't do a plea deal, that's considered absolute. So it's not really like a detailed confession that you give. You just say, I plead guilty to the charges, or I plead not guilty, or eventually no context, which in some places is what you do when you want to take a plea deal, which, like I said, is the most common outcome for most criminal cases in the United States is for there to be a plea deal. So you take a plea deal with the prosecution, and you get a reduced sentence. Sometimes you get not to go to jail, but you don't get to go to trial. The pre-trial proceedings, the plea bargaining, you have the right to consult with your attorney before you accept the plea bargain. Like I said, the attorneys in criminal defense affairs are provided by the state. So this was established in the case Gideon versus Wainwright. So even during questioning, before the trial, you are allowed to consult with an attorney, and that's going to be paid for by the state. And this is a big problem in the United States because there's a lack of defense attorneys. So a lot of them don't have enough time to actually analyze the case. It can be, and a lot of people are not aware of their right, which is one of the reasons that Miranda warnings exist, to let people know that they have the right to legal representation. Probable cause, that would be a standard for a police officer to conduct an arrest. You can also have a warrant. And we studied this in our constitutional law, and we're going to see this in greater detail, what the exceptions to the exclusionary rule under the Fourth Amendment are, because usually you need a warrant to do most things in the United States by virtue of the Constitution. And that's good because there's a lot of overreach that is done by police departments, and that is a big social issue in the United States. So the requirement to have a warrant serves as a limitation against that. Miranda rights, like I said, established by the case Miranda versus Arizona. We're going to see them in detail. You have the right to remain silent. Anything you say can and will be used against you, and you have the right to an attorney. If you cannot afford an attorney, one will be appointed for you. Those were established in the 1960s by the decision Miranda versus Arizona, which you do have to read as a part of this course. That is one of the 10 cases that you have to read. So the justices do discuss that. So the indictment, this is interesting. In certain jurisdictions, so in around half the states and at the federal level, because of the Fifth Amendment talks about grand juries. And what grand juries are, and I explained this during the constitutional law class, they are these jury tribunals organized without the defense attorney. It's just the prosecutor and the judge. And basically the point is just for the jurors to decide whether or not there's enough evidence to indict the defendant. They say, yes, we vote in favor of the indictment, then the case goes to trial. So he's not guilty yet. He's just going to trial. When we do jury proceedings in Brazil, we have a similar procedure, which we call the pronúncia. In some cases, that's going to be done by the judge. But at the federal level, because of the Fifth Amendment in about half the states, that's done by a grand jury. Jury, a group of citizens, like I said, all cases that can result in more than 6 months of imprisonment in the United States have to happen through a jury trial unless there's a plea bargain. So this is an interesting aspect. And it's really, like I said, a cornerstone of common law, which, when you have a jury trial, it's a lot easier to have, this idea of the law being this easy to understand thing based on principles of natural justice and not these abstract philosophical concepts, because ultimately criminal matters are decided by the jury, and in other cases civil matters are decided by the jury as well. When we're going to see that when we study civil procedure. Yes, so habeas corpus, obviously this is something that we have here, but we got from the common law jurisdictions. The writ of habeas corpus, extremely important. You can challenge the legality of an arrest. So it's called the writ of habeas corpus. It originated in England with the Magna Carta and with the Bill of Rights in 1688, which we analyzed during the class about English constitutional law. And it is something that exists in the United States as well, and it's extremely important. And it was suspended actually during the Civil War by Abraham Lincoln, but it's still a constitutional right to have the writ of habeas corpus. And the Constitution does outline sort of a mechanism to suspend that right in the case of great political turmoil, but it still is a constitutional right. And there has been some criticism of Abraham Lincoln for his decision to suspend the writ of habeas corpus. Double jeopardy, very important. Basically, the Constitution says you're not going to be put twice on jeopardy of life and limb for the same crime. So that means that if you've been found not guilty, you're not going to be convicted again. You're not going to go to trial again. If the jury has found you not guilty and there were no procedural mistakes that were made, then that's never going to go to trial again. What's important to analyze is that double jeopardy only applies to the state and the federal level. So you can be tried twice if it happens once at the federal level and once at the state level. You cannot be tried twice at the state level and tried twice at the federal level. If you're found guilty, you can still appeal your sentence, or maybe there's been a mistrial. So there's still some leeway to sort of try to get a new trial. But basically, double jeopardy protects your innocence if you're found not guilty. And these statute of limitations, like I said, like here, there's also statute of limitations in the United States. Basically, when you commit a crime, there is an amount of time that is given to the prosecution and to the state in general to actually prosecute you for that offense. You're not going to be liable for that criminal offense forever. Of course, there are exceptions, and this is going to vary state by state. Some states have no statute of limitations for any crimes, while others do for all crimes, so this is going to vary from each state to each state. Constitutional protections. The Bill of Rights has a lot of protections against regarding criminal procedures. So the Fourth Amendment, unreasonable search and seizures. Basically, you need a warrant. The Fifth Amendment, self-incrimination and grand jury. And the Sixth Amendment ensures the right to a jury trial in all cases. And the Eighth Amendment basically deals with, cruel and unusual punishment, excessive bail and fines. The fines part is not litigated very much, but when it comes to cruel and unusual punishment, we saw this with criminal law. This is something that is litigated extensively. And also excessive bail at the federal level is also something that is analyzed, because bail basically being similar to the idea of fianza is extremely common in the United States. Here we don't judges usually don't set bail as often as they do in the United States, but in the United States it's done almost all the time in a criminal proceeding. The exclusionary rule from Matt versus Ohio, also part of the case law that is mandatory. So basically, we hold that all evidence obtained in violation of the Constitution shall be excluded. This is what the Supreme Court decided. There are exceptions to this, such as inevitable discovery, hot pursuit. I'm going to go over those. It is extremely important. Any unconstitutional evidence or illegal evidence is to be excluded, even if that means that the defendant is going to be found not guilty. Yeah, so basically, Katz versus United States. Also, dealing with privacy and the importance of the Fourth Amendment. This is, you will see a lot of these important decisions from the 60s, so it was a period of great, very important decisions in American history. And a lot of them are being reviewed right now by the new conservative majority in the Supreme Court. So exceptions to the exclusionary rule, independent source doctrine. So if you would be able to get that evidence from another source that is not the one that's been tainted by the illegality, then that's still admissible. Inevitable discovery, maybe at first it was illegal, but that evidence kept coming up so much and so often that you would have found out anyway. So that's also an exception to the exclusionary rule. Attenuate, this is not something that is being used anymore. Basically the idea is that you got the illegal evidence at the beginning, but it's been a long time, and over time it's been attenuated. That doesn't really work anymore because it would be too broad and would lead to too many violations of the exclusionary rules. But it's still important to be familiar with that term. Search incident to a lawful arrest. So this is something that was, if you remember the decision Terry versus Ohio. I did not put that as mandatory reading, but it's in the drive, our drive with the files. Basically, the police have the right to search you when they conduct an arrest for weapons and things like that. That was held as valid during the Terry versus Ohio case. Also, because the justices argued that it was not an unreasonable search, which is what is prohibited by the Constitution. So if they're searching you as a result of an arrest and they find something, that's also fine. You don't need a warrant for that. Plain view doctrine. Basically, if you're holding something or it's visible in your body, the police don't need a warrant to confiscate or to search you for that specific thing. Hot pursuit. Basically, this is mostly for homes. So if you're running away from the police and you enter your home, they can chase after you without a warrant, even though usually you need a warrant to enter somebody's home. So that's what hot pursuit means. Exigent circumstances. This is a bit broader, but basically, if there's an immediate danger, this is something that shows up in TV shows. If there's an immediate danger or some reason that might, to safeguard public safety, where the police have to enter the building, they're also allowed to do that. But this is very broad, and obviously there's a lot of case law involving this. Some other older exceptions that I didn't put here because it's not used anymore, but there was something called the silver plate doctrine. So basically, if the defendant, basically silver plate meaning, the evidence was so easy to find, we just had to do it. Obviously that sounds a bit ridiculous, and it's going to be leave a lot of margin for arbitrary behavior by law enforcement, so it's not used and applied anymore, but it's something that used to exist. Stop and frisk, basically Terry versus Ohio, like I said, the police have the power to search the defendant for weapons when they conduct a lawful arrest. And this was used extensively, you had in the 90s and the 2000s in the United States, in New York, there was this wave of stop and frisk, basically just stopping and frisking anyone on the street, even if you had no evidence that they committed a crime. And this was certainly something that was litigated, but originally they meant a lawful arrest can result in a frisk. So basically you could pat that person down for weapons and you search to see if they have any weapons. And if you do find something, then that can be used in court. DNA evidence, this is a recent case, Maryland versus King. Basically, when you arraign someone, when you take them in for, or when you take them for booking at the police station, you're allowed to conduct a buccal swab. So basically, take some DNA evidence in a way that's not very invasive, some DNA material, to basically compare it to the database. This was held to be constitutional, but it is certainly questionable how, especially in view of the idea of medical privacy. But today, one interesting aspect is that this is becoming less necessary because there's so many people voluntarily giving away their DNA material through websites such as Ancestry.com or these DNA databases that the police can just compare those DNAs to the existing to the person, and usually they can find the suspect that way. So, but still, Maryland versus King, the Supreme Court ruled that police stations could collect some DNA material from the people that they took in for booking. Right to an attorney, this is Gideon versus Wainwright. This is mandatory reading. There was a law in Florida that the state was only going to provide an attorney in capital offenses. So basically, if the death penalty was involved. But the Supreme Court said, no, that's unconstitutional. It has to be in all cases. And this is separate from the idea of a jury trial. So even, misdemeanors, and basically you are always entitled to an attorney when it comes to criminal matters. This I took from this law firm in the United States. These are the Miranda warnings. So you've heard this in movies several times. You have the right to remain silent. Anything you say can and will be used against you. You have the right to consult an attorney before answering questions and to have an attorney present during questioning. So this is to remind you that usually the Miranda warnings are read before the interrogation. Sometimes they're read during the arrest as well. And if you cannot afford an attorney, the court will appoint one to represent you. The right to remain silent, very important. This doesn't just apply to interrogations. Sometimes if you're called to testify, for instance, in a Senate hearing, you cannot, if it's your own trial and you choose to take the stand, you can't plead the fifth. But in other cases, you can. You can just say, I plead the fifth. That means I'm not going to say anything because if I do, I might incriminate myself. So that's what it means to plead the fifth, the Fifth Amendment. And anything you say can and will be used against you in a court of law. We discussed this, if they read you the Miranda warnings, then anything you say after that is fair game in court. Even if you're intoxicated or if you're feeling stressed or under duress, that's still fair game. All it takes is for the police to read them and for you to sign something or provide some sort of consent that implies that you understood the rights. So that's why they always ask you, did you understand those rights as they have been read to you? Right. The right to stop questioning at any time. If you say, I want to stop questioning now, if you're the police doing the interrogation, you say, I do not wish to answer any further questions. They have to stop the interrogation right there. Anything you say after that usually is considered not admissible. But really, and this is something that lawyers will tell you, it's never worth it to disclose anything during interrogations because the courts have ruled, also because the police have an incentive and they have procedures and techniques that they use to extract things from suspects. There's something called the Reed technique, or the idea of good cop, bad cop. There's a multitude of interrogation techniques to get the defendant or the suspect, in that case, because they haven't been indicted yet, to basically admit to anything. Really, it's best never to reveal anything to the police. Anything you wish to say, you're going to say after consulting with an attorney in court. And you're going to testify in court, or you're going to provide some sort of statement in court. Basically, this is the part of the reason that the Supreme Court used to create the Miranda warnings, which are obviously based on the Constitution. The idea that the police environment of an interrogation is inherently not abusive, but unequal. There's a power disparity between the suspect and the police. There's a lot of things they do to make the suspect more likely to confess. For instance, they usually do it late at night. They put themselves in front of the door. They have multiple people. There's they sort of have a friendly demeanor to get the person to confess to something, even if they haven't done it. Also, Miranda versus Arizona, the warning will show the individual that his interrogators are prepared to recognize his privilege should he choose to exercise it. Yeah, so you should always exercise your privilege to remain silent and your right to remain silent if you're ever in a situation where you're brought to a police custody. Griffin versus California, this is a different case. The right to remain silent cannot be used against you. So if you wish to remain silent in court, the prosecution in a jury trial cannot say, well, if he's remaining silent, then that must mean he's guilty. They're not allowed to say that. This is what was decided in this case. Right here you can see either comment by the prosecution or the accused silence or instructions by the court that such silence is evidence of guilt. So if you remain silent, the prosecution cannot use that against you when they're arguing in front of a jury. They just have to accept that. So investigation, basically gathering information, identifying suspects. A number of ways to identify suspects. You have a lineup, which is basically when some people go to the police station. Usually they choose different people with different features so that you can be identified from a group of random people. But this is stuff that is very familiar to us from movies, but it's also part of criminal procedure. Forensic analysis, ballistics, DNA. There's a problem with forensic analysis in the United States is that before reliable DNA evidence was around, they used a lot of things which were unreliable. So bite marks or dental analysis that was proved to be very unreliable. Another thing that doesn't work is the polygraph, so the lie detector. They still do that, but that cannot be used in court. Courts have ruled that the evidence is so unreliable that the polygraph analysis cannot be used in court. So it's basically a bluff by law enforcement to get the person to maybe feel pressured. So additional investigation. In the conclusion, they send it to the prosecutor, and the prosecutor can file a complaint, or he'll decide if he wants to press charges, and he sends that to the judge, and then there's the indictment. We'll see that. So grand jury is at the federal level and in about half of the states responsible for the indictment of the defendant. Because at that point, there's still a suspect. Basically, the prosecutor will present the evidence the police collected and whatever else he might have requested. He'll basically say, well, do you think that this should go to trial, that there's enough evidence to take this person to trial? And then the grand jury will rule yes or no. So when it comes to the federal level, that is mandatory by the Fifth Amendment, but at the state level, that is not mandatory, and it's really only used in certain cases and in certain states. It is a secret proceeding, and it is another thing that's interesting is that it's something that happens without a defense attorney, so it's just the prosecutor and the jurors, because it's supposed to be a little bit faster, and there is this idea of preferring to take the case to trial, because then the things can be, analyzed further. So this is something we have here as well, where it's preferable to the legal system to take things to trial than to not take things to trial. Because if the grand jury says no and doesn't indict the suspect, then the case ends there. But if they say yes, we indict it, then they're not determining guilt or innocence. They're just saying let's go to trial and find out more. So the prosecutor still has a discretion, because like I said, after the person is indicted, there's the possibility of a plea bargain. So the prosecutor will use that discretion to offer a plea bargain or not. And it's important to note that prosecutors are elected officials in the United States. So you vote for your prosecutor and you elect them to be the district attorney. That's why, there's this incentive, maybe to prosecute more serious cases, sometimes to offer a plea bargain. So the prosecutors are not always, acting in accordance with these abstract procedural philosophies. Sometimes they're thinking more politically than really the way we see it here. These abstract ideas, which is why it's important to have jury trials, because if the prosecutor is an elected official, and sometimes even the judge is an elected official, then, because of the political reality we live in, there's going to be, a tendency to convict people, which is why it's important to have the jury to compensate for that. So information of complaint. So basically, if the prosecutor thinks there's enough evidence and he gets the indictment, he can file the complaint. We call this, this is similar to the idea of a denuncia, which is this written document that states the case and basically introduces the criminal proceeding. And the grand jury, the defendants have the right to waive their grand jury right as well, because it's a right under the Fifth Amendment. It's meant to protect them. It's not meant to make things harder for them. So it's an additional protection. They can just say, well, I'm so convinced, or I just want to go straight to trial, so they can waive their right to a grand jury as well. So a pool of potential jurors. The voir dire, this is a French expression. Basically, you have this the prosecution and the defense attorney. They will use their challenges, and one of these challenges is called a peremptory challenge. So it's basically a challenge that you don't have to explain why you're doing it. You just take someone off the voir dire, so off the pool of jurors. You cannot do that on the basis of race, and that was decided in the case Batson versus Kentucky. Basically, you use that to maybe get a jury that is more likely to favor your case over the other person's case. But the prosecution and the defense attorney have the right to these peremptory challenges in civil cases and in criminal cases. The opening statements, I put a video with that on the exercises. Because it's a jury trial, there's a certain theatricality to it. So you have to introduce the case in a way that's easy to understand. Really, you have to present a narrative to the jury, which is going to, seduce them to vote in your favor. The presentation of evidence, the prosecutor will present the evidence. You show, oh, look at this DNA analysis, look at these pictures, look at these photos. When they're doing that, and when, for instance, when they call a witness to testify, the other party, so the defense counsel can oppose it. They can file an objection. You can say, oh, Your Honor, this is hearsay, or Your Honor, this isn't relevant evidence. This is not connected to the case. Basically, the judge will act as the sort of preside over the trial, so that the juries will not be persuaded with bad or illegal evidence or illegal arguing or illegal lines of thinking by the prosecution or even by the defense. The prosecution can do challenges as well. And then after that, there's a closing argument. So basically, you present a narrative, you show your evidence for it, and you say, well, that was the case. And usually, they'll do it in a way that is a bit, trying to perhaps appeal to the jurors in a way that's perhaps more intimate. Not really. Well, this is something you see in jury trials here as well. It's not really based on abstract legal ideas. It's more based on, there is an emotional element to a jury trial, and the prosecution and the defense will try to exploit that in the closing arguments. After that, the jury will deliberate. When it comes to a criminal case, the decision has to be unanimous. They will either decide to convict or not convict. And then the sentence, the penalty, if they do convict, is going to be decided by the judge. So yes, so you have this presentation of evidence, and the verdict which the jury has to reach has to be unanimous. So they either decide guilty or not guilty. And then the sentencing, that means, what the defendant will face as a result if they're found guilty. So basically the penalty for their crime is going to be decided by the judge based on the law. Obviously, there are limits to the sentencing powers. If the law doesn't say, well, there's no death penalty for this case, and there's no death penalty. The death penalty, there's a lot of limitations to it, but this is all dealt with statutory provisions. The judge will usually comply with. Well, they have to comply with those. And also, it's customary in the United States for the judge to present his own opinion at the end of this case. That is usually recorded. So that is something that is also strange to us, because we see the judge as almost this sort of like technical figure which is above the case. But at the end, obviously, after he's issued, the judge has reached a conclusion, he doesn't have to be impartial. So obviously, he's gonna, uphold what the jury decided. He'll issue a sentence. Say, well, you get this much time in prison or community service. Or if the defendant is found not guilty, obviously there's no penalty to be applied. And he will also issue, some sort of statement like, oh, this is a case where I thought this and this. Basically, sometimes there can be an additional decision if the defendant is found guilty on whether or not they should face the death penalty. And that can be another thing that the jury will deliberate. So that they don't always just deliberate on the guilt of the party, they also sometimes deliberate on other things as well. But usually the sentencing part is done by the judge. A peremptory challenge is basically the exclusion of a juror without the need for any reason and explanation, but that cannot be done on the basis of race in a way that would result or amount to discrimination. This was decided in Batson versus Kentucky. And basically, you can use a Batson challenge to challenge the other party's peremptory challenge if you think they're doing it on the basis of race. So if they exclude for instance, all the African American jurors, and you think, well, that's discrimination, you can use a Batson challenge to question that before the court. So yes, here Batson versus Kentucky. Purposeful racial discrimination in the selection of the veneer violates the defendant's right to equal protection. Also, they speak of the idea of public confidence, which is very important, in part because, there's all these, the law is usually very long and detailed, and the police, there's a lot of discretionary police power that's being utilized. The jury part has to be legitimate in order for the judicial system to be legitimate. The confrontation clause, this is important, and this is also a principle of common law. It's in the Sixth Amendment. Basically, you cannot have secret evidence. You have to confront the defendant with all the evidence against him. That includes witnesses. So there's a case called, let me see here, Roviaro versus the United States. Basically, they didn't want to reveal who the witness was, but the defendant was like, well, given that the whole conviction is being based on the witness, I want to know who that person is, I want to see them. And that basically prevents the state from basically making ghost witnesses. And here, this is important, Joan Doe and Jane Doe, these are names used, like placeholder names used for people who do not wish to disclose their identity. So in a lot of sexual assault cases, you're going to see, Jane Doe being the victim, or John Doe if it's a man. So basically, that's just someone who doesn't want to reveal their identity. Here we have Value versus the United States. This was a part of the decision that the jury panel has to have at least 6 members. Below 6, that's in the Constitution. It's a violation of the Sixth Amendment. So yeah, it's usually 12, but it has to be at least 6. Right. So types of evidence. This is similar to our system. You have expert testimony, witness testimony, physical evidence. If the other party brings an expert testimony and you want to challenge whether or not that person really is an expert in that field, you are allowed to do that. And the admissibility is going to depend on the legality, right? So under the exclusionary rule, no illegal evidence is to be admissible in court. But there's also a lot of other things. It's not just how the evidence was created, but also what the evidence is. So what I said about the polygraph, that is not admissible evidence in court. The polygraph is so unreliable that it cannot be used as evidence. So there are a lot of rules pertaining to what can and cannot be evidence in a criminal case. The burden of proof, obviously, this has to be that way. The burden of proof always lies with the prosecution. All persons are innocent until proven guilty, and you have to be proven guilty beyond a reasonable doubt. So if the prosecution's arguments are tenuous, if they don't have a lot of evidence, you can be let go, and for a lack of evidence. The judge will rule not guilty because there isn't evidence beyond a reasonable doubt. Objections, you see there's a lot of movies, but it's true. Basically, you can object to several things. You can file challenges, not just objections at the moment. You can file challenges. Basically, a Batson challenge for the peremptory challenges with basis on racial discriminations. You can challenge whether or not the witness is really an expert. You can impeach the witness, which basically means you're saying that the witness is biased. So if the witness has some sort of connection to the victim, maybe, you can impeach the witness to expose any biases that they might have. So this is sort of similar to the idea of a contradita, right? So you were impeaching the witness. Also, there's cross-examination. So when a witness is brought forth by either party, the other party also has the right, basically, to question the witness to make sure that that their deposition is consistent. So basically, we refer to that similar idea, the idea of acariciar, acariação, that means basically cross-examination in the American legal system. So cross-examine the witness. That means both parties get to question the witness. Jury deliberation. The jury then retires to the jury room. Well, basically, like I said, the deliberation is secret, and the jurors don't have to decide to disclose why they found the defendant guilty or not guilty. But they do have to reach a unanimous decision usually. Bail hearings. Before the trial, and this is done sort of in a different order. Before the case goes to trial, there's a bail hearing. So the suspect is presented to the judge, and the judge is like, well, based on what I saw, I set your bail at this amount. It cannot be an unreasonable amount under the Constitution. Basically, the judge decides if the person will be let go on bail or if they're going to stay in prison until the trial. Basically, the preliminary hearings, basically that's going to be, when there's no grand jury, you have to have a preliminary hearing to sort of determine whether or not there's enough evidence for the case to go to trial. Suppression hearings, basically, you can file a motion to have something suppressed. So if you say, well, this evidence here is not legal, it's not reliable, so I want to have a hearing to suppress that from the other parties, the evidence that they are allowed to present in court. Because the problem is that you're not presenting the evidence to a judge, you're presenting it to the jury. So if the jury hears something that's illegal in terms of evidence or something that's unreliable, that's going to influence their opinion, even if they're told later that it's not legal evidence or it's not reliable evidence, because they aren't common people, they're not legal experts. So all the evidence has to be reliable and legal before it is brought to the jury. Probation or parolings, after you've been convicted, and there's usually this procedure called parole. Basically, every few years, if you have good behavior, you can be let go on parole. So you're going to be off on the streets under certain conditions, and you have to present yourself to your parole officer. If you don't obey those conditions, you can go back to jail. Present tense investigation, basically, this is the probation officer that comes in before the sentencing part. This is also interesting because you have to analyze the defendant's background before issuing a sentence, and then you have the sentencing hearing. So basically, the judge is going to use his own discretion. Obviously, there's legal limits to determine what the appropriate sentence is. Usually, it's a lengthy prison sentence, and it's very easy. Some states like California have something called the 3 strikes rule. So basically, if you're found guilty for 3 offenses, even if they're relatively minor, you get a life sentence. So really, judges in the United States tend to hand out very long sentences, and they're backed by the law when they do that. So appeal, you have the right to appeal a sentence, obviously, and you have the right to get a remedy for that sentence after the conviction. So like maybe you want to file a habeas corpus, maybe you want to file a writ of habeas corpus after your conviction, and you have here some different types of sentences, right? So like I said, community service, but usually it's imprisonment. So usually you go to jail. Double jeopardy, very important. Double jeopardy clause, no one shall be put twice to jeopardy of life and limb. That basically means that you cannot be tried twice for the same crime. And then the same jurisdiction obviously doesn't apply for the federal and state level as separate. And if you're found not guilty by a jury, then that is absolute. The prosecution cannot appeal that sentence, and it's not going to happen again. So if the procedure is okay and the judge finds you not guilty, then you're off forever. Basically, double jeopardy, obviously extremely important. It comes even from medieval England, like I said in our first class, where French was spoken. So basically, you have the idea of autrefois acquis or an autrefois convict. So if you've been found not guilty once, you're not going to be put to trial again maybe because some new evidence showed up. So if you've been acquitted once, so if you've been acquitted some other time, you're not going to be put to trial again. So that's double jeopardy. So here's some steps: the arrest, probable cause with or without a warrant. After you're arrested, you're taken to the police station. They take your fingerprints. They take a picture, a mugshot is what you call that. They might take a buccal swab of your DNA for DNA evidence, and basically that's called booking. And after that, the prosecutor will analyze the evidence and file a complaint if they see fit with the judge. Then you go before the court to have a bail hearing where the judge will determine whether or not you'll be free to leave or if you're going to stay in jail until the trial actually happens. It's going to depend on the crime, obviously. The preliminary hearing, this is going to depend on whether or not it's a grand jury state or not, so it's going to depend on the jurisdiction. But if it's a felony and the judge is not sure, before they take the case to trial, they'll have a preliminary hearing. So filing of indictment or information, when you indict someone in a grand jury state or in the federal courts, you do it in front of a grand jury, which is what I've explained. But if there's no grand jury, usually it's going to be the judge's discretion whether or not the person is going to be indicted. That's why the prosecutor will go and recite the charges, basically repeat this procedure, and the judge will then decide to indict or not indict the person. Then you have the arraignment, which is when the defendant pleads guilty or not guilty, or possibly no contest. No contest is just something you plead in some jurisdictions when you take a plea bargain. So basically, I'm not going to oppose the charges being filed, but I took a plea bargain. When you plead guilty, that is absolute. You can also take a plea bargain when you plead guilty or not. You can just plead guilty and accept the charge, the sentencing. And then not guilty when you do that, when you plead not guilty, then you go to trial. That's the only case when you go to trial. And actually, this is a minority of cases because most people plead guilty or no contest in order to obtain a plea bargain. Pre-trial motions. So, for instance, you want a motion to change venue to a better place, a motion to suppress or suppress evidence, or maybe dismiss the case entirely for lack of evidence. Those are things that the attorney or even the prosecutor can file before the trial begins. Then trial, sentencing, and appeal. I explained that. After that, you have the remedies, right? So one remedy being the writ of habeas corpus, the very most important remedy possibly in a legal system when it comes to criminal procedure. And those things you do usually after the conviction. Then the imprisonment can have any length of time. All states in the U.S. have life imprisonment. So usually, murder in most cases tends to lead to life in prison. And then when you have life in prison, you can have it with or without the possibility of parole. So if you have the possibility of parole, maybe after 20 or 30 years, you're going to have some sort of parole hearing where they determine if you're capable of going back to society under the terms of the probation officer is going to set for you. Fines, they can also be you can also be convicted and sentenced with a fine. The Eighth Amendment does also protect against excessive fines, but they've never really gone to court too much because American courts tend to just sentence people to prison, even for relatively minor offenses. It would be difficult to see a case where a person just gets a fine after a criminal conviction instead of a prison sentence. Usually fines happen in civil cases. Probation would be something that happens, after you've been in jail for a while, you get the chance to go out on parole, so you have a probation officer who will make sure that you are obeying the rules that he set to you. Maybe you can't go to certain places, you can't go out at night, you can't drink alcohol, so there's a number of conditions that are set for a defendant to be let go on parole. Well, in that case, they're already an inmate. When you go to the jail system, you've already been convicted. Community service, for smaller crimes and less serious offenses, misdemeanors, you can get community service. So you're gonna have to help the community, you're gonna have to paint houses, pick up litter, so pick up garbage. And then obviously restitution, where you have to pay back the victim for the crime you committed, and capital punishment being the death penalty, which is subject to a number of limitations, as was discussed under the Eighth Amendment. You cannot execute minors, you cannot execute people with intellectual disabilities. You have to execute them in a humane way. So, you can't burn people alive, you can't behead them. It has to be, something like a lethal injection or firing squad or gas chambers. Those are things that are considered humane forms of execution. And then basically the appeal, you file a notice of appeal with the court, and then usually you're gonna end up going to Well, it's going to depend on what kind of crime it is. If it's a crime at the state level, then the final court that can hear that case is going to be the Supreme Court. Eventually, you can file a sort of writ of certiorari to the United States Supreme Court. Maybe they'll be willing to hear your case, but usually it's very hard to get into the U.S. Supreme Court to hear. They hear very few cases. Basically, it's a similar procedure, to any other trial. There's no jury. You just have the oral arguments. And usually, when it comes to this kind of thing, you're going to argue something based on procedure. So basically, you're going to say, well, the prosecution used bad evidence, they committed illegalities. But like I said, the jury convictions are hard to overturn because juries, there's this idea of, the sovereignty and the importance of the jury trial. So it's going to have to be some major, procedural mistake which might make that jury ruling void. So here's some important case law. I put it in much more. Basically, if just this class, you can read these cases here for some sort of rudimentary understanding, but like I said, criminal procedure is litigated extensively, and there's a lot of Supreme Court precedent on it because the Constitution talks about criminal procedure a lot. Yeah, please, if you wish to work with this or write about this or know more about this, read more case law than this. This is just a starting point for you. All right, so I'll see you in the next class, and thank you very much.